On Friday, a federal high court in Abuja convicted and sentenced 2 of the 4 defendants alleged to have kidnapped Chief Mike Ozekhome SAN to a 20-year jail term each. Justice Binta Nyako, in a judgment, held that the prosecution had been able to establish the counts preferred against Kelvin Ezigbe and Frank Azueko, who were first and second defendants, beyond reasonable doubt. Justice Nyako held that the sentence would run from the day of their arrest. The judge, however, discharged and acquitted Michael Omonigo and Momo Haruna, who were third and fourth defendants of the counts leveled against them in the terrorism charge. She held that though some of the counts against Ezigbe and Azueko attracted punishments ranging from death sentence, life imprisonment to at least 10 years jail term, she said she had found that the accused had been remorseful of their criminal act. She said she also found that they had been in custody for about 10 years since their arrest. The news agency of Nigeria reports that while Omonigo, who was said to be the chief priest, was in court, Haruna was not. The judge, however, directed that Haruna, who was at large, should be brought to court to face the scene of his escape from lawful custody, even though he was discharged of the counts against him. The judge commended the defense lawyer, Bala Dakum, and the prosecution counsel, Chioma Onwegbu, for their diligent input during the trial. None report that the defendants, Kelvin Ezigbe, Frank Azueko, Michael Omonigo, and Momo Haruna, were first arraigned before Justice Adeni Ademola of FHC on June 9, 2014, on a 13-count charge bordering on conspiracy, armed robbery, kidnapping, and acts of terrorism. While the 3 defendants were in court, Haruna was said to be missing after the attack on Kuje Correctional Center by terrorists on July 5, 2022. They were accused of committing acts of terrorism contrary to sections 1, 8, and 10 of the Terrorism Prevention Act 2011. They were alleged to have, on August 23, 2013, kidnapped Chief Mike Ozekhome at Irekwe on his way to Ivikwe in Agenebude, Edo State. Ozekhome was held in captivity for about 3 weeks before his release, allegedly following the payment of 28 million naira ransom. They were also accused of kidnapping Delta State Commissioner for Higher Education, Professor Hope Egaga, Athanasius Ugme, and his friend Emmanuel Maka Omorogbe, and killing 5 police officers and 2 prison officials.
Actually serve a deterrence to the convicts and other suspects out there. My Lord actually delivered an erudite judgment. This case started for the past 10 years. It has not been an easy journey. It started before Honorable Justice Ademola. When he now retired, the matter was now given to my Lord Justice Nyako to handle. It has been a very tough time for our officers of the criminal justice system, and to equally tell the public that the officers of criminal justice system are still working. Thank you very much.
Please, can we have your full name?
My name is Chioma Onwegbu. I'm a deputy director in the Federal Ministry of Justice.
Delivered by the court. I'd like you to react to it. Your client got 20 years. How do you feel?
It wasn't the best of feelings. We did a good job in the course of the trial. So it's one of those things that happen in criminal cases. But we'll take the necessary steps to do the needful.
Okay, so is it correct that once a defendant pleads for leniency from the court, that he or she has admitted the judgment by the court and cannot appeal that judgment?
No. Plea for leniency is just saying that, okay, having convicted me, whether right or wrong, I need you to give me a least sentencing. I need just deliver the sentencing, with some discretion. Use your discretion and give me the least sentence you can that is permitted by the law. Not that I'm guilty. It's just saying that having found me guilty, give me the least sentencing. And it gives condition why the court should act on, because discretion is not given on a vacuum. You give the court reason why they should give you least sentencing. That's exactly what they did.
Thank you.
Yes, thank you. My name is Baladaku.
No, let me correct an impression. First of all, I represent the 4th defendant in this matter. The issue before the court was not a case of unlawful custody. You understand? So the court never found my client guilty of unlawful custody. The court only made that point, that even though it has discharged and acquitted the fourth defendant in this matter, my client still has a case to answer because he escaped from lawful custody. And if you see when I was thanking the court, I told the court that when we get to the bridge, we will know how to cross it. We will now determine whether it was a lawful custody or not. Do you understand what I'm saying? Whether it was indeed a lawful custody or not, because we believe it was not. We believe that in this case, the DSS went on a wild goose chase in this matter. And the court clearly made that point clear. My client was standing trial on a 5-count charge, bordering on kidnapping and receiving illicit fund and all that. The court saw that. It was just an empty charge, a very bogus one. They were just making sporadic arrests. And unfortunately, my client was there at the time and he was arrested. So the issue of escaping from lawful custody, when they arrest him, if they arrest him, they will now charge him properly for unlawful custody. Then we will now represent him. Do you understand me? And determine whether that custody in itself was lawful. So at this point, when we get to the bridge, we'll know how to cross it.
Let's have a comment.
My name is Ahmed Tijani Yusuf, and I represent the fourth defendant who has just been discharged and acquitted on a Haruna Momo 5-count charge bordering on kidnapping and receiving money from illegal proceeds. Thank you very much.